Hi everyone, this is Daniel Chesmore. This is the second part of our video series on evidence for the bar review. We'll focus this video on character evidence. So character evidence, broadly defined, is evidence of a person's character or character trait. There are four kinds of character evidence to determine a witness's credibility. These are acts, supporting other inferences, reputation, sometimes deliberately misrepresented, character traits such as someone being reckless or violent, and propensity, really meaning a tendency to act in a particular way where we attack truthfulness. Now, number one, we always ask whether or not this character evidence is proof of a witness's propensity to lie or to tell the truth, showing witnesses' untruthful character under 40481 of the Federal Rules of Evidence. So under 40481, this proof is allowed to attack the fact witness's credibility with some limitation. The opposing party may show the witness's untruthful character by 608A, which states that present a character witness who offers reputation or opinion evidence about or testimony about the witness. Character witness may not give specific examples of the witness's untruthful behavior. Cross-examiner may ask character witness about witness's prior specific instances, such as a bad act or crime, but may not offer extrinsic evidence to impeach what the character witness says. Under 608B1, cross-examine witness about witness's prior specific incidents, bad act, crime, showing untruthful character. We must accept the witness's answer and may not offer extrinsic evidence to impeach what the witness says. So criminal conviction of a witness is an example of proof of a witness's propensity to lie, tell the truth. We look for truthfulness. And so we've got this interesting chart here. We start with, is the character evidence offered to show action conformity with the character? If the answer is, in this case, if the answer is either yes or no, we get different results. If the answer is no, then admissible if it offered to show knowledge, intent, plan, preparation, opportunity, motive, identity, or absence of mistake or accident, etc. If the character reputation is an issue, citing to Gilbert, is the evidence offered by a criminal accused to show his good character, or the prosecution to rebut the same, by a criminal accused to show the victim's bad character, or by the prosecution to rebut the same, by the prosecution to show a criminal accused bad character after the accused has attacked the character of the victim for the same trait, to reflect on the credibility of a witness, to show a person's commission to other sex crimes. For example, if the answer in that case is no, then it's inadmissible. If the answer is yes, then admissible. So remember that exception, that if it's offered for knowledge, intent, plan, preparation, opportunity, motive, identity, or absence of mistake, it can be admissible. So under 404A1, evidence of a person's character or character trait is not admissible to prove that on a particular occasion the person acted in accordance with the character trait. This is otherwise known as propensity evidence. So in a defamation case, for example, where some salacious TMZ headline might say, for example, the worst celebrity tippers are some celebrity, Ariana Grande, for example. The Ariana Grande introduces evidence proving that her character is generous. Nothing in the process that involves propensity. It's relevant. Nothing in 404A would actually prohibit this. Ariana Grande in that example may introduce these evidence to show her generous character, reputation among other celebrities, opinion of neighbors, testimony from waitresses. When the character is an element, proof is not limited to reputation, opinion, or testimony. There's no restriction there. And you can even prove character as an element through specific acts. So testimony from waitresses, for example. The salacious headline can introduce this evidence to show that Ariana Grande is cheap. Ariana Grande's misdemeanor conviction for kicking a waiter, complaining about no tip. That doesn't exist. We love Ariana Grande. This is just a hypothetical. It could be any celebrity. So as long as consistent with 403, 609 criminal conviction doesn't apply here. 609 only limits introduction of convictions to show lack of witnesses' truthfulness. Here we are using conviction to prove element of the case. B's friend testifies that, in his opinion, Ariana Grande is one of the most generous people. The tabloid can respond by cross-examining about Ariana Grande's cheap acts, introduce evidence of Ariana Grande's cheap acts as long as they're relevant or passes 403. That's a hypothetical, but just remember this chart here, which is pretty useful, that if it's a criminal accused to show good character by the prosecution to rebut the same, or if it's a criminal accused to show the victim's bad character, or by the prosecution to rebut the same, or the prosecution to show a criminal accused bad behavior after the accused has attacked the character of the victim for the same trait, or to reflect on the credibility of a witness to show a person's commission of other sex crimes. That is, if that's the case, if the answer is no, then it's inadmissible. If the answer is yes, admissible. And remember those exceptions for Kiphimia, thank you Gilberts, for knowledge, intent, plan, preparation, opportunity, motive, identity, or absence of mistake or accident. I love Gilberts. You should definitely buy all of their books. Very useful for law school and for review. Just fun reads. I think they do a good job summarizing much of the law. Proof of defendant witnesses propensity act to prove a fact, that falls along 404A1. So proof of conduct by propensity is usually not allowed. There are exceptions to this. So for example, if the defendant hits a victim because he has hit lots of other victims before, he has a violent character and propensity to hit people, that's not allowed. If one person is suspecting another for stealing something from her garden, like a gnome or a plant, and sues for trespass to chattel, a tort claim for theft, then another example is a target manager testifying to someone stealing a CD. Or, I mean, if it's relevant, if the defendant there is more likely to steal, that might violate 404A1. 404A1 is a prohibition against character evidence. If the defendant was convicted of stealing from Target, then in that separate case with the neighbor and in the gnome case, the neighbor could introduce this only if the defendant there testifies and this is a felony. And remember that conviction is not admissible to show the defendant's propensity to steal, but 609 does allow some evidence of convictions to impeach witnesses' credibility. Theft is not a crime of dishonesty, so it must be a felony to really impeach. The defendant can invoke 403 to exclude this evidence, as we talked about in our first video. And over here, the defendant is not a criminal, so 403 would apply. The neighbor, in that case, in a separate, regarding the defendant's separate case for theft at Target and theft for the gnome for the neighbor, she might dislike the defendant and say the defendant will steal anything. That's not admissible as propensity evidence. Foundation won't help. There's no cross-examination there. Evidence of the defendant wearing some sort of "let's steal things from neighbors" button, not admissible if it is just to show propensity, but might be admissible to show knowledge, intent, plan, preparation, opportunity, motive, identity, or absence of mistake or accident, for example. Evidence of the defendant there, in that case, not admissible, again, to show propensity. If the neighbor saw her property missing from her lawn, there's a pile of empty beer cans, then the neighbor could introduce this evidence to show that the defendant is an alcoholic. The majority thinks that this is a character trait, but cannot introduce this evidence to show that the defendant is a litter bug, someone who leaves trash all over. That might be more propensity. If the cans had the defendant's fingerprints on them, then that might be admissible. It's not a propensity argument. If the cans don't have fingerprints, but the neighbor has evidence that the defendant drinks a beer brand, the neighbor could introduce evidence to prove the fact that the defendant has a tendency to drink this brand. But, however, the defendant is more likely to be the person who left the cans and stole the property in dispute. Not admissible there is a propensity argument. If the neighbor introduces this as a marker of the defendant's identity over there in Kiphimia, then that is actually admissible. So 404A2 talks about the mercy rule, which is pretty important. propensity in criminal prosecution for both the defendant and witness. When it can be shown that the person might have acted in accordance with his trait, the mercy rule applies usually to criminal cases and only to criminal cases. It allows the defendant, as denoted in these highlighted questions there, thank you again, Gilbert, to allow the defendant to introduce evidence about his character or the victim's character. The character trait must be pertinent. The prosecutor may respond but not initiate. So that mercy rule usually applies and only applies to criminal cases where defendant can introduce evidence about his character or the victim's character. Character trait must be pertinent and the prosecutor may respond, but the prosecutor can't usually initiate. They can rebut, as it says in the questions there. And so an example from my professor in law school was that there was a defendant living in a house that a friend was constructing. Defendant thought the friend would sell him the house, but he refused to sell. Defendant got angry and cut the whole house in half horizontally with a power saw, and the state charged defendant with vandalism. State calls a neighbor testifying, "I've known the defendant for 30 years, he has no respect for property." That's not admissible. 401 would prohibit that under character evidence, since it would be the state actually first bringing up that evidence, and the state can actually rebut, but can't be the one bringing up the evidence first. A woman from the defendant's church testifies saying that the defendant had been attending the church for 20 years, he's peaceful and law-abiding. That is admissible under 404A2. But however, over here, 610, actually, I have that here somewhere. I think in these rules over here, you can take a moment to pause if you need to and look over here on much of what I have written. And so there, under 610, a woman from defendant's church testifies saying that defendant had been attending the church for 20 years, he is peaceful and law-abiding. In that case, it's admissible under 404A2 since it's the defendant bringing that witness first. 610, however, bars evidence of religious belief to establish a witness's credibility, but the woman is not referring to defendant's religious beliefs or defendant's credibility. She may be biased in favor of the defendant since they're a member of the same church, but that's not a basis for actually excluding the evidence, however. You need to find some sort of other objection, maybe relevance or 403, for example. And so, not referring to defendant's religious beliefs in that example or defendant's credibility. However, the witness may be biased in favor of the defendant because of the fact that they're a member of the same church, but that's not a basis for excluding the evidence. State can bring this to point out through cross-examination, however. But if the defendant calls a witness who testifies, defendant is clumsy and scared of power equipment, defendant will argue that he's not the type of person who could have committed the crime. It may be admissible, but this is not a clear-cut rule. It's an unusual character trait, technophobia, for example, but plausible still to argue. What if the witness there keeps testifying that defendant is so scared of power equipment that he won't even use a blender? That's not actually admissible under 405A because witness cannot use specifics to back up opinion or reputation testimony there. So you would object and say specific acts and a prohibition under character evidence. And so there, yes, not admissible. Witness, again, cannot use the specifics to back up opinion or reputation testimony. Only the original testimony is allowed. Can the state ask the witness on cross-examination, are you aware that that defendant uses a power lawn mower? That it would be allowable under 405A, which does say that by offering a character witness, the defendant opens that witness to cross-examination on specific acts. What if the witness says, "Oh, no, I didn't know that. Can the state introduce evidence of defendant using it?" No. The rules don't allow extrinsic evidence on character evidence. So remember that over here, extrinsic evidence, I have that written as extrinsic evidence of prior inconsistent statement, inadmissible there unless the witness afforded an opportunity to explain and deny the same, an opportunity there where opportunity afforded to interrogate or intent of justice requires, DNA, admission of the opposition there, and prior statement, we'll talk more about that. Prior statement need not be shown or disclosed to opposing counsel. So we'll talk a little bit more about that where in later on. And so, again, if the witness says, no, I didn't know that, state cannot introduce because that is a prohibition on the extrinsic evidence. You can't use extrinsic evidence on a character trait. Can the defendant introduce testimony that the friend is untrustworthy, who hasn't kept their promises? Then probably not. If a criminal defendant wants to introduce evidence of victim's character trait, it must be pertinent. Even if the friend did, that's not a defense of vandalism. Another case where, another example you might have at an arcade/restaurant, the police broke up a fight, started with profanity and went physical among several girls, arrested a girl who landed the most punches, defendant and charged her with assault. The defendant there is 18, so they introduced evidence that the defendant punched 6 girls, including the victim. Defendant calls a neighbor who testifies she's a sweet-tempered young woman. That is admitted because the defendant is allowed to make a propensity argument for her own character under opinion and reputation, but the defendant opens a door there. The state can actually cross-examine that witness and say, did you know that the defendant repeatedly beat up her sister? That's admitted because on cross-examination you can ask those specifics of 405A. You can ask those specifics which the criminal defendant brings up in their defense, I guess. And so if the witness says, no, I didn't know that, can the state introduce evidence of the defendant actually using it? No, because remember, the rules do not allow for extrinsic evidence on a character trait. They can't bring that in. They have to find some sort of other way to bring that in if they can, but there is that weight against that prohibition on extrinsic evidence. So remember the state can cross-examine the witness there on the specifics. The state can, if you're going to ask, can the state cross-examine the witness, for example, did you know the defendant shoplifted from another store? That's not admitted because cross-examine must actually be relevant to the testimony. Can the state cross-examine the witness, did you know a defendant was convicted with assault? That may be admitted. The state can test witness's knowledge by asking questions related to her opinion. So that is, again, part of kypomia: knowledge, intent, plan, preparation, opportunity, motive, identity, or absence. So state can test the witness's knowledge by asking questions related to her opinion. 609 doesn't actually apply in that circumstance then. And we've got that written kind of related rules here. And under 609, you don't have to worry whether it was a felony. This shows why character evidence can actually backfire, because once a defendant introduces a character witness, the state can cross-examine about specific acts, for example. About specific acts. What if defendant won an award for good behavior from her high school? No clear answer there. It depends on the judge and how good the attorney is. Reputation or opinion is admissible. Specific acts are inadmissible. So what if the defendant won an award for good behavior from her high school? No clear answer. It depends on the judge and how good the attorney is. Reputation or opinion is admissible. Specific acts inadmissible. So courts tend to treat it as a specific act inadmissible. So remember to differentiate specific acts, which specific acts are usually inadmissible, but reputation or opinion that a defendant brings in could be admissible. So we have to differentiate those. Can the state call a character witness to testify that a defendant has a violent nature? Yes, actually, under 404A2B, but the state cannot initiate character evidence, but can rebut it, as we talked about in our flow chart. Can the state introduce evidence that the victim was sweet-tempered? No, because the state cannot offer character evidence about the victim. What if the defendant killed the victim? Can state offer evidence about victim's sweet nature? Only if the defendant offered evidence that the victim was the first aggressor. So the same situation, but defendant claims self-defense. Can a defendant offer a witness testifying that the victim had violent nature? Yes. Remember that whether or not it's a homicide case, If the defendant claims self-defense, then the victim's character is pertinent, so the defendant can't offer that. Can the state offer reputation evidence on rebuttal? Yes, because the defendant in that case has attacked victim's character, and the state can rebut, as we have there as another example. But in talking about the victim's character, the defendant has to offer it first, and then the state can rebut. Same situation, but defendant offers no character evidence about herself, but offers evidence that the victim was violent. On rebuttal, can the state call a witness to testify that the defendant is violent? There, yes, under 404A2B2. If the defendant offers, or the defendant attacks the victim's character, then the state can counter with character evidence about both victim and defense. Attacking the victim's character is more of an aggressive action. The state and jury don't take the defendant's character evidence seriously. Yeah, so remember, when the defendant attacks a victim's character, the state can counter with character evidence about both the victim and the defense. Attacking the victim's character is a more aggressive action, however. The state and jury don't take defendant's character evidence seriously. So here's another example. A food fight. Student A hit student B in the face with a salt shaker and broke student B's nose and was charged with aggravated assault. Student A claimed self-defense. Student B was angry at student A for dating A's ex-girlfriend and started this fight by swinging his fists, and the student A ducked and threw the salt shaker to defend. State calls a witness who testifies that student A is aggressive and prone to violence. That is inadmissible because the defendant hasn't yet opened the door. The defendant has to be the one to first open the door. But if the defendant there, student A, calls a witness testifying that he is gentle and nonviolent, that is admissible. And then in the rebuttal, the state can call that same witness to testify that student A is aggressive and prone to violence. So remember, we have to wait until the defendant opens that door for the state to rebut. Because in that case, the state is it's not admissible. The state is responding to the defendant's propensity evidence. State calls a witness saying that student B is meek and wimpy. It's inadmissible because the defendant hasn't opened the door yet, so we can't talk about the victim yet. And however, if the defendant there calls a witness to say that the victim is belligerent, always picks fights, then it's admissible. That character evidence is admissible. In the rebuttal, the state calls the victim saying that, or state calls a witness saying that the victim is meek and wimpy. That's admissible. The defendant can cross-examine that witness and ask if the witness is aware that the victim has a prior conviction for assaulting his live-in girlfriend. It's admissible. Specific act evidence is admissible on cross-examination. If he is aware that the victim has a prior conviction for selling drugs, for example, it's inadmissible because it's not a pertinent character trait. Neither reputation, opinion, or specific acts are admissible there. So in rebuttal to witness testimony, the state calls another witness testifying that the defendant is aggressive and prone to violence. That is admissible because if the defendant attacks the victim's propensity, the state can attack the defendant's propensity as well. And so in that case, if the defendant calls a witness testifying that she was with the defendant in a bar one night when a drunk man threw beer in his face and challenged him to a fight, and in response the defendant ran away and hid in the bathroom, that's inadmissible because that's a specific act. We can talk about general character, like if the defendant calls in a witness that says that the victim is belligerent, always picks fights, that is admissible because that's not really a specific act. Remember, we have to distinguish the specific act versus reputation, for example. So we have the reputation or opinion. Reputation and opinion will be admissible, but not the specific acts. And so there, that's a good example. What happens when the defendant sues a witness or sues the victim for battery seeking civil damages? None of these evidence would be admissible in a civil case, because these are criminal cases. We're talking about criminal accused in those questions. Very different set of rules when we talk about civil. This is okay for criminal, but it's inadmissible for civil damages. And so third, when is a defendant witness's character an element of the case? Proof of character or reputation as elements, they're allowed, but in rare circumstances. There are 5 examples. They're just good to know just in case they show up on multiple choice, for example. They're defamation, child custody, entrapment, negligent entrustment. For example, where a basketball coach sends one of his players to the airport to pick up a high school recruit, the player in the car ran a stop sign and hit a trailer. The recruit can introduce the following to prove the coach's negligence, such as the player's reputation for bad driving, the player's former passengers who testify that he runs stop signs, and other testifying that the player drinks and drives, or proving damages, loss of consortium, lost wages, pain and suffering. So those are 5 examples: defamation, child custody, entrapment, negligent entrustment, proving damages, where proof of character are as elements, and they're allowed if they're elements of a crime, like defamation, child custody, entrapment, negligent entrustment, proving damages. Fourth, use of the defendant's or witness's other specific bad acts, but not necessarily prior acts, to show the defendant or witness's propensity for other purposes. Use of other acts for non-propensity purposes we talked about, they're allowed usually. Under 404B, that's where we get a lot of these rules, where evidence of a crime, wrong, or act may be admissible for another purpose. We talked about kypomia, for example, where Rule 404B confirms that we can introduce evidence that can be shown to show propensity for other purposes, one of the most frequently litigated rules. So, for example, the defendant is charged with burning a victim. The burn has a characteristic shape like a branding mark. Prosecutor offers evidence that the defendants have branded other victims with just burns in the same shape. This evidence could be used to suggest that the defendant has a propensity to burn people. However, it could also be used to identify defendant as to suggest that the defendant has access to a branding tool in the shape. So that is over there, like preparation. It could be knowledge, plan, for example, where it's allowed under kypomia. Prosecution wants to prove that the plaintiff was a main, or that one person was the man robbing the customers. So their evidence was the defendant was himself, or the defendant himself was a customer in an illegal activity. Propensity route, where the defendant has a propensity to break the law, defendant is more likely to be guilty. Legitimate route, the victim there knows the defendant, identification is reliable, defendant is probably the robber. Prosecution has a legitimate argument for using the evidence to identify, again, identity there, identify the defendant. However, significant risk that jury will travel propensity route. Under 404B2, evidence of a crime, wrong, or act may be admissible for another purpose, where Rule 404B confirms that we can introduce evidence that could be used to show propensity for other purposes. One of the most frequently litigated rules, again, where a defendant is charged with, actually we talked about that, sorry, the burning example. Moving on, if the prosecution has a legitimate argument for using evidence to identify the defendant, that would fall under kypomia. But remember, there's a significant risk that the jury will travel that propensity route, so we've got to be careful. So the evidence may be admissible for another purpose, such as proving motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. And we'll go through each of these. So for knowledge, for example, imagine if a defendant was arrested and prosecuted for illegal drug trafficking. While waiting trial, she was arrested again for another illegal drug charge. She denies knowing about the drugs in her car. Prosecution offers evidence of the second arrest during the trial and the first arrest. It is most likely to be admitted if there are related crimes there, where 404B doesn't require any sequence, not prior, but other acts there. And so extreme coincidence to drive 2 cars across the border, both containing cans of drugs and gas tank without knowledge. Motive, an example of motive is that the evidence exists that the defendant is a bank robber. Defendant's name on the note telling the bank the bank teller to put all cash in a bag. The teller identifies him as a robber. That's okay. Prosecution discovers new evidence. There, the defendant uses drugs with his neighbor, and the prosecutor can argue that defendant needed money there to support his addiction. Defendant can argue 403, over there, 403, in that there's unfair prejudice and the rule of exclusion should apply. The court may exclude relevant evidence if its probative value is substantially outweighed by danger of unfair prejudice, depending on how often the defendant used the drugs, whether defendant had financial difficulties. If defendant only used the drugs occasionally without financial difficulties, the probative value of the evidence is weak. Prosecutor discovers new evidence. Defendant told his neighbors that he robbed the bank. The neighbors want to testify. Prosecutor wants to bolster the credibility of the neighbor's testimony by showing that defendant and neighbor used drugs together, making them confidants. Neighbor was the type of person that the defendant would have spoken honestly. Seems weak because the defendant there can show that they're friends without drug abuse. So unfair prejudice would substantially outweigh any probative value, and that would be excluded under 403. So balancing these allowable exceptions under Kiphomia for character evidence against 403 is pretty crucial for a good essay on the bar exam. So intent, defendant is arrested with possessing large bags of drugs. Prosecutor wants to convict the defendant as a dealer. Proving intent depends on the amount of drugs or paraphernalia for distributing packaging, a statement the defendant made to others, records of sales, setting up transactions. What if the defendant had been previously convicted for selling drugs? Would that be admissible? If the defendant sold drugs before, then the defendant is likely to be doing it again. Is the defendant possessed, can we prove the defendant possessed drugs to sell? Probably not if it's under propensity, because it shouldn't be allowed under propensity. However, courts frequently allow it for drug cases. It depends on the prosecutor. Neither route is ethically wrong. Intent, continued there. Defendant is arrested with possessing large bags of drugs, we talked about. Intent or plan, the overall pattern there. When we talk about the plan, kind of relates to intent. Defendant's wife had found the victim dead in the bathtub right after making a will in favor of the defendant. Investigation showed that defendant had been married twice before using different names. Both his wives died the same way. Prosecution wants to get the defendant for his most recent wife's death. Are the other deaths admissible, or is this propensity reasoning? Prosecution's argument relies on an overall pattern there. And so we don't know whether the defendant acted in any of these cases. Doctrine of chances. Pattern suggests an intent or a plan. And so what are the chances that this would have innocently occurred 3 times? Defendant was convicted and executed there. Other cases of intent or plan are employment discrimination cases. Workers argue race, sex, disability, age discrimination. Employers argue financial need, worker incompetence. Most courts allow both parties to show other instances that suggest or negates discrimination. Doctrine of chances, pattern suggests motive. If an employer fired everyone over 40 and hired everyone in their 20s, or if the employer fired only one person over 40 and hired many people, look at the overall pattern. It may be allowed actually under 404B. It's somewhat different than using propensity argument, which is not allowed. So in one case, an actress was found dead, shot with the defendant's gun in foyer of defendant's home, who is a music producer. Defendant claimed that she was despondent, saw the gun and shot herself. Prosecution claimed defendant shot her, probably after she refused sexual relations with him. Prosecution called 5 women as witnesses, each testifying that they dated him and that he suddenly pulled a gun and threatened them. Incidents over 30 years. And so in that case, the defendant argued that evidence was improperly admitted to show motive, identity in the absence of mistake, accident, or suicide. It should have been excluded as more prejudicial than probative, and was improperly used by the prosecution to allow some sort of showing of a pattern of behavior that was relevant to the question of how the victim died. However, there the defendant lost and is currently in prison. So always remember 403, even when evidence of other acts show motive, knowledge, or some other non-propensity fact, it also shows propensity. Therefore, the 403 balancing test is especially important, even if a party makes a legitimate case for admission under 404B. And always ask if the court carefully considered prejudice as well as probative value. And so next we'll talk about habit evidence. Habit refers to Habit usually refers to four factors: specific behavior or conduct that occurs in a distinctive situation on a regular basis, and preferably without moral overtones. So very specific behavior that occurs on a very regular basis might qualify, even if it is spread across a variety of situations or with moral overtones. And we have to distinguish habit from propensity, where propensity depends on internal character. It assumes that there's something about this character that influences actions, for example. And so it assumes conscious choice that is influenced by this character or nature. For example, choose to give low tip because I'm cheap, for example. Habit is regular actions regardless of internal character. We can say that the actions occur without saying anything about the character. For example, when given a lab sample to test, the technician always puts on gloves. Maybe in other contexts she's very sloppy, but has developed a specific action related to the test. Remember these four factors when distinguishing habit from propensity. So we look at specific behavior conduct occurs in a distinctive situation on a regular basis and preferably without moral overtones. So another example of habit evidence is that I bring my refillable water cup to class 3 nights a week in room 501. And so a very specific behavior, particular drink, water, place, time of day that occurs on a regular basis and lacks moral overtones in that example. Evidence about a person's habit is not character evidence. So we distinguish habit from character evidence. So the evidence offered does not have to be limited to opinion or reputation. So habit is often proved through eyewitness testimony about very specific behaviors. What if I always bring a beverage to class every day, but some days I bring tea and some days I bring Gatorade? Still a regular behavior, bringing a beverage to the same place and time every day with no moral overtones. But on the other side, I can argue the behavior isn't quite as specific because I vary the beverage. The habit isn't quite as relevant because I don't always bring water. The judge might still admit, still quite a habit that doesn't rest upon my character. Problem with this evidence relates more to its relevance. A professor who has never bought a beverage to class or never drinks coffee would be much less likely to have caused a stain. Therefore, the evidence is still relevant, and there doesn't seem to be much unfair prejudice. The school can just introduce evidence that I brought cups of water into the room without relying on habit. And even if no one saw me spill a cup, the opportunity is relevant. What if I tripped and spilled beverages in different places 6 times in the last 2 months? That's not really a habit. It's not a specific or regular. I don't do it all the time. Then in that case, it's more of propensity. I'm clumsy. It's more likely I spilled the coffee that caused a carpet stain. Burglary. Another example is a burglary occurred at 10 a.m. on a Sunday morning. Defendant testifies that he was a local diner, drinking coffee at that time. Witnesses testify that defendant always goes to the diner on Sunday mornings. That's admissible. Conduct seems specific and regular without propensity thinking or moral overtones. Can the defendant use their own testimony to establish his habit? Admissible. Rules specifically say that witnesses or corroboration are not necessary. Lack of corroboration goes to weight of the evidence. The defendant offering his testimony brings specific concerns. The defendant takes risks on cross-examination, however, for opening the gates. So the prosecutor may also probe other parts of that story there. So defendant risks impeachment without any prior convictions. Jury may wonder why, if this behavior is so regular, defendant can't find anyone to corroborate. What if the defendant says that he was at church at that time? Witnesses testify that defendant comes to church every Sunday. There's no clear answer. Judge may be uneasy about moral implication. Church attendance seems to invoke character propensity thoughts more. 610 does not bar this evidence. 610 only excludes evidence of religious beliefs to show credibility of witnesses. For example, plaintiff crashes car into tree at 6 p.m., sues defendant manufacturer claiming steering defect. D claims P was drunk. Can defendant introduce evidence that P drinks at 5 p.m. every day? No clear answer there. Advisory committee notes suggest that drinking alcohol usually is not a habit. Worried about unfair prejudice in the case of drinking, for example, where the jury will use this for character evidence, but this act can be very regular. Need more specifics to come up with an answer. If plaintiff drinks same amount of same brand at same time every night, Routine practice of businesses and other organizations. Courts are more tolerant in admitting this evidence because organizations more often are very consistent in their practices. For example, plaintiff purchased homeowners insurance from defendant covering wind and hail damage but not water damage. Based on defendant's agent's representation, plaintiff believed that it covers water damage during a hurricane. Together with wind and hail, defendant refused to pay for water damage when it happened. Plaintiff testifies that he asked the agent whether to purchase separate flood insurance. Agent discouraged plaintiff. Plaintiff supports his claim with other testimony that whenever customers ask the agent, he discouraged them. Routine practice of discouraging clients from buying flood insurance. This can be argued either way, depending on the specifics there. And so if an office manager testified against an agent, if the agent made the comment to only 5 customers out of many others, just look to those facts. And so also, we'll study the Rape Shield Law, Rule 412, which is very important in this concept. So under Rule 412 there, classic case example, defendant meets a victim at a bar, goes to her place, they both agree that sex occurred, victim says rape and defendant says consent. Can the defendant introduce evidence that the victim is promiscuous? Under 404A1, this prohibits propensity arguments, except in this exception under 404A2B, where the defendant can introduce evidence about victim's character. Willingness to consent to sex is a pertinent trait. 404B allows any party to introduce evidence of specific acts to prove something else other than propensity. Defendant might be able to introduce evidence of victim promiscuity, such as under intent. However, there is a general prohibition against evidence of victims' other sexual behavior or sexual predisposition. So criminal cases, there are 3 exceptions to cover situations in which information is essential for defendant's legitimate defense. Sexual behavior related to physical evidence, sexual behavior with the defendant, where the defendant argues consent and the prosecution argues any purpose, and to satisfy the Constitution. And so there, defendant charged with rape, and the defendant denies any sex with the victim. Semen was found on victim's underwear, but DNA testing is inconclusive. Can the defendant introduce evidence that victim had sex with her boyfriend the day of the alleged rape? It's admitted there because the prosecution is relying upon physical evidence. Prosecution can avoid defendant's defense by not introducing the evidence of the physical evidence at all. So defendant is charged with rape. Defendant admits sex but claims consent. On direct examination, the prosecutor wants the victim to testify that she was a virgin before this incident, relevant to show that she did not consent. It's not admitted, however, because it's a propensity argument. Absence of sexual behavior equals other sexual behavior or sexual predisposition. 412 applies to the prosecutor as well as defense. If 412 didn't apply, then 404A would. Since the defendant hasn't made a character argument, the prosecution cannot introduce evidence of victim's pertinent character to rebut. If the victim told the defendant that she was virgin before the sex, the victim could testify to the fact, relevant to show that she did not consent under Kipomia. And so there, not admitted, actually that is admitted, it's relevant to show that she did not consent. What if the defendant wants to introduce evidence that the victim told her friends, I've been dreaming about sex with him, whatever, it's admitted, specific instance of sexual behavior with defendant admissible to prove consent. This person is so attractive, I just wish I could get some alone time. That is unclear because the statement is too ambiguous for 412 to apply in that circumstance. And does she want to just talk to him, or does she want to engage in the sexual relations? Peter, a 6-year-old child, claims that the babysitter raped him. Babysitter wants to introduce undisputed evidence that 2 months after the alleged rape, Peter was raped by a neighbor. Both the babysitter and the neighbor are men. That's admitted, complying with the Constitution. To have it admitted, defendant might argue at this age consent is irrelevant. We don't have to prove Peter is promiscuous. Prosecutor has a wrong person there under identity for Kipomia. So neighbor raped the victim twice or more. So defendant is charged with rape, and can the defendant offer evidence that the victim falsely accused another man for rape last year? That's admitted, complying with the Constitution. Defendant is not trying to prove that the victim had sex with anyone. Defendant and victim were dating. Victim accused D, defendant of rape. D, claims consent. Victim's roommate testifying that victim had birth control pills in her room, not admitted. Possession of birth control is actually a sexual behavior, not a specific instance of behavior that victim engaged with defendant. Victim might be taking the pills for health reasons, propensity that 412 excludes. So civil cases, evidence of the victim's other sexual behavior or sexual predisposition is excluded unless the probative value of that evidence substantially outweighs the danger or harm to any victim and of unfair prejudice to any party. It's a reverse 403 test. And so the civil rule applies to any case involving sexual assault or alleged sexual misconduct. For example, tort claims based on rape, sexual harassment claims, because the defendant can argue that the victim welcomed the harassing behavior. For example, Wendy sues McDonald's claiming that her supervisor created a sexually hostile environment. Wendy's evidence is the supervisor made crude sexual jokes and invited her to join him for a quickie. McDonald's wants to introduce evidence. Wendy frequently trades crude jokes with her friends, and she's known for one-night stands. That's excluded. In applying the weighing test, a very important factor is whether behavior occurs at work or outside the workplace. The way we behave at night is relevant to the way we behave during the day, but its probative value doesn't substantially outweigh harm to plaintiff. If Wendy wore tight, low-cut shorts and very short skirts, then not clear but probably excluded. Clothing probably isn't evidence of other sexual behavior, but plaintiff might argue that this is evidence of sexual predisposition. Or prosecution, defendant offers the evidence thinking it relates to plaintiff's sexuality. Oh, it's a civil case here, so yes, plaintiff. So plaintiff should be able to exclude this under 412. Even if 412 doesn't apply, 403 should exclude. So propensity in sexual assault and child molestation cases under 413, 414, and 415. So there, in those cases, in those rules, propensity evidence in sexual assault and child molestation is allowed. Police officers asking women to perform a variety of sexual acts in exchange of tearing their arrest records. May the prosecutor offer another unrelated woman's testimony saying that one of the officers forced women to perform oral sex when she was pulled over for a routine traffic stop? Yes. Evidence of previous assault showing propensity for assault, that there's an exception for that under propensity evidence for sexual assault and child molestation cases, and that falls along with a lot of these public policy arguments for why that should actually be admitted. And so next we'll talk about hearsay. We'll talk about more about these rules, the 600 series on rules. We talked a lot about what can be relevant and admitted and for policy reasons. We talked a lot about character evidence, and I think last year we'll just really quickly talk about 615, exclusion of witnesses. At request of party, court shall order witnesses excluded, so cannot harm testimony of other witnesses, and may order on their own motion. No exclusion of party who is a natural person, officers or employees of party, not natural person designated as representation by attorney, or persons whose presence is sentenced to the presentation of his cause. And so we'll talk more about hearsay next, and that is basically all we need to know for multiple choice and for the essay on character evidence. Remember, once again, we'll just go over this really quickly since it's so important here. This chart is super useful, thanks again Gilbert's, where we first asked, is the character evidence offered to show action conformity with character? If the answer there is no, it's admissible. If it's used to show kypomia, knowledge, intent, plan, preparation, opportunity, motive, identity, or absence of mistake or accident. And then ask yourself, is evidence being offered by a criminal accused? And the first three of those five talk about a criminal accused to show his good character, show the victim's bad character, or the bad character after the accused has attacked the character of the victim for the same trait. That's admissible, but that opens the door so that on cross, the prosecution can also ask about that, but the prosecution cannot be the one to open the door. It has to be the defendant. 4 or 5 on the list of questions talk about to reflect on the credibility of a witness or to show a person's commission of other sex crimes there. And if the answer there is no, then that's inadmissible. If the answer for those 5 are yes, then admissible. And so next we'll talk about hearsay.